Well, good morning, everyone, and welcome to today's broadcast on Gough Square Live. I hope you've all enjoyed previous Gough Square Live broadcasts where we've had topics such as time limits, charging the right defendant, and of course my personal favourite, consent, connivance and neglect. And all of these are available on the Gough Square channel. Now, this morning, Robin Kingham is going to speak to you about the very important and imminent changes to the primary authority regime. As always, please send in your questions during the talk, and Robin, will do his very best to answer those at the end. Like Cameron Crowe, my technology prowess is very limited, and technical questions are likely to be met with a shrug or jazz hands. But I will do my best to try and answer any technical problems you may have. Over to Robin.
Great. Thanks very much, Alison. Hello, everyone, and thanks very much for tuning in. Today, I'm going to be giving you a whistle-stop overview of the changes to the primary authority regime that are due to come into force on the 1st of October. Since we only have a short time to go over the changes to the regime today, I'm going to assume that everyone is familiar with the primary authority regime, and in particular, the Regulatory Enforcement and Sanctions Act 2008, known as RESA. However, if you're looking for an overview of the background to the primary authority regime, how it came about and how it works, then I'd recommend flicking through the very useful section on it in the 5th edition of the Pink Book. That's Consumer and Trading Standards, Law and Practice, edited by our very own Brian Lewin and Jonathan Kirk QC. The proceeds of it all go to the British Heart Foundation and the Meningitis Trust, and it gives a very good, concise summary of the area. So, plug done. On to the changes. What's changed and why? Could I have the first slide, please? Well, it's worth pointing out at the outset that one of the underlying drivers in this change is the government's desire for more businesses to make use of the primary authority scheme. A lot more, in fact. There are currently about 17,000 businesses participating in the scheme, and the government wants to increase that number to 250,000 by 2020. And clearly, that's going to put a strain on the system. And so a number of changes have been introduced that are intended to streamline the legislation and make the system easier to administrate in order to make the mass provision of advice to businesses sustainable. Also, some of the changes are intended to make advice given by primary authorities more robust and more authoritative. With that in mind, the key changes that we're going to look at today are 1. Structured involvement by national regulators such as the CMA and the HSE in supporting primary authorities. 2. A new default position where primary authorities will be responsible for the whole range of regulatory functions rather than the old situation where functions were broken up into categories such as food standards or fair trading. And 3. Changes to the definition of enforcement action to future-proof the legislation. I should say that those aren't the only changes that are going to happen. For example, pre-startup businesses will now be able to enter into primary authority relationships, as will businesses with trade only in, or that trade only in one area. However, we don't have time today for a fully comprehensive look at everything that's changing, so I'm just going to focus on the 3 most significant changes that I think everyone working in the area should know about. Before I do that, though, I think it may be worth briefly setting out how these changes are being brought about. Could I have slide 1 just for a minute again? Thank you. There are 2 major pieces of legislation that implement these changes, both of which are coming into force on the 1st of October this year. The first is the Enterprise Act 2016, which substantially amends RESA, and in particular introduces a new Part 2, which is the part setting out the basic framework for the primary authority regime, and also a new Schedule 4A, which deals with disagreements over proposed enforcement action and refers to the Secretary of State. Otherwise, RESA will remain more or less the same. The second piece of legislation is the Coordination of Regulatory Enforcement Regulations 2017, known as the Core Regulations. This is a brand new statute that actually doesn't take very long to read. It's only about 7 pages long, so it can easily be read on a lunch break or if you need some help getting to sleep at night. The core regulations set out the specific details of the changes, for instance, specifying which national regulators will be the so-called supporting regulators, which brings us neatly on to the first change that I mentioned, which is the introduction of a system of supporting regulators. Can I have slide 2? This is created by Section 28A in the new Part 2 of RESA. And the idea is that certain national regulators, specifically the CMA, FSA, the Gambling Commission, the HSE, and the Secretary of State, will be brought in to support primary authorities by providing specialist knowledge and expertise. The sorts of things that the government has in mind include specific hands-on support, such as access to testing facilities and technical knowledge, as well as broader coordination support, such as a wider perspective on inspection plans and national inspection strategies. The government's hope is that primary authorities will benefit from this support and coordination from specialist national regulators, and that in turn will give weight to advice given by primary authorities. In return, primary authorities will be able to give their supporting national regulators insight into regulated business communities and experience of regulation at the coal face. How will this work? Well, there's clearly a lot of organisation that's going to need to be put in place by the 5 supporting regulators. Systems and teams will need to be established to deal with the primary authority relationships, and measures will need to be put in place to ensure consistency across the scheme. The government's also made clear that it's made it clear in the draft statutory guidance that it expects supporting regulators to publish details of the nature and of the extent of the support they'll offer, as well as any criteria that they'll use in deciding whether to provide support to a primary authority. As with primary authorities currently, of course, supporting regulators will be able to charge businesses on a cost recovery basis for the support that they provide to primary authorities. So that's the first change. On to the second. Could I please have slide 3? The second change is the removal of the category system. As I'm sure that many of you will be aware, the primary authority system currently operates by reference to categories. So a business partner will partner with an authority in respect of one category, for example, food standards or fair trading. The primary authority relationship, as a result, doesn't automatically cover everything that the authority regulates. It's limited to whichever categories have been agreed. There are currently 22 different categories, which is a number that's increased over the last 8 years. It's also been clear that the number of categories was going to grow even further as new regulations and regulatory functions were implemented. As a result, the government's been firmly of the view that this approach with categories was unsustainable, unnecessarily complex, and that it added to the burden of administering this scheme, all of which are clearly major problems if you're going to grow the scheme to include 233,000 new businesses over the next 2 years. So categories have been scrapped, and what we have instead is a system where, as a default position, primary authority partnerships will cover all of the relevant regulatory functions that are within the particular authority's responsibilities. Now, there are a lot of concerns raised during the consultation process about this change. In fact, the majority of local authorities that responded to the consultation said that they weren't persuaded by the rationale behind the change. In particular, there was the view, quite convincing in my opinion at least, that the new system would restrict options for businesses. So businesses wouldn't be able to shop around and pick different local authorities for different categories depending on the particular expertise or resources that authorities had in certain areas. The government's answer to that is really twofold. One, tough luck. The scheme needs to expand exponentially, and that isn't going to happen under the current model. And two, well, the new blanket approach to partnerships is only the default position, and it'll still be possible for bespoke arrangements to be agreed by authorities where businesses, for example, have complicated or layered arrangements with several local authorities that mean the default position is inappropriate. Could I have slide 4? So on to our final change, which is the new definition of enforcement action. This may seem like a very dry technical topic, and in some senses I suppose it is, but it's important because the definition of what counts as enforcement action goes to the heart of what an enforcing authority can and can't do without notifying the primary authority. The current definition of what constitutes enforcement action will be familiar to many of you. In essence, it sets out a list of all of the various types of notices fixed penalties and so on that local authorities might issue, as well as citing the particular statutes under which the notice is issued. This means that every time a new set of regulations comes out that includes a new type of statutory notice, the definition of what counts as enforcement action has to be amended to include it. As a result, there's inevitably a delay between when a new set of regulations comes out and when it's brought within the scope of the primary authority regime. It also means that the current definition is clumsy and not at all straightforward. The new definition, however, introduced by Regulation 5 of the core regulations, does away with this approach. From the 1st of October, we'll have a new definition that simply lists a variety of types of notice, for example, an enforcement notice or a prohibition order. Any of those notices will count where they're issued under a relevant enactment. In other words, any notice issued with a basis in statute. This is, in my view at least, a clear improvement over what we had previously and has made the definition much easier to read. It's worth noting, though, that this generic approach doesn't mean that anything goes when it comes to what constitutes enforcement action. The relevant notice has to have a statutory basis, so enforcing authorities still won't have to notify primary authorities where they send out warning letters or other similar correspondence that doesn't have a basis in statute. With that, I'm afraid we've come to the end of this whistle-stop overview of the changes to the primary authority regime coming into effect on the 1st of next month. Anyone who's interested in learning more about the new legislation can access the government's response to consultation from Chamber's website in our newsfeed section. There's also the new draft statutory guidance, which is available online on the gov.uk site, and that provides a much more detailed look at how the primary authority regime will operate. And of course, if you have a particular problem or a question relating to the primary authority regime, or indeed anything relating to local authority enforcement, then we here at Gough Square Chambers are always very happy to help. On that note, I think we have time for a couple of questions, if any have come in whilst we've been speaking.
Well, yes, Robin, actually we do have a couple of questions. Firstly, we have Michael from South West London, and he says, what about the referrals process? Isn't that changing too?
Well, I think the short answer to that is no. It was considered, I believe, as part of the consultation process. During the consultation, some concerns were raised by stakeholders that the Secretary of State in particular might have a conflict of interest where, under the new system, the Secretary of State acted as a supporting regulator in the particular case in question. But nothing's been done. So concerns notwithstanding, the regime will stay more or less the same, although a new bit of statute has been included to take account of the changes that have been made elsewhere by the Enterprise Act.
Thank you, Robin. And we have one further question. Stephanie in Walthamstow asks, are the 5 regulators the only supporting regulators? She says, what, for example, about an agency such as the Environment Agency?
Nope, there are only 5 at the moment. I agree, I don't necessarily understand the rationale for that. You would have thought perhaps the Environment Agency or other national regulators like the ASA might have been included. I don't know whether perhaps it's envisaged that in the future the number of national regulators will be increased, or whether there was some other reason for not including them, but for the time being at least it is limited to those 5.
Thank you, Robin. Those are the only questions we have. So thank you very much for your very informative run-through of the primary authority regime changes. If I could just tell everyone that the next broadcast of Gough Square Live will be on the 28th of September at 11 AM. And on that day, Michael Coley, assisted by Richard Roberts, will talk about insolvency and the effect that this can have on regulatory proceedings. So obviously a very important topic for local authorities and when they're investigating and considering bringing proceedings. So thank you all very much for watching, and we look forward to you joining us next time. Thank you, Robin.